So, what happens to your business when you die? Most business owners haven't answered that question, and if you haven't, your business may potentially not survive you. But today in this video, we're going to answer that question and then provide you with some solutions. So, I'm Michael Tarro Jr. I am a business attorney down here in Tampa, Florida. I'm also licensed in Rhode Island, but of course, the fact that I'm an attorney does not mean I am your attorney. This video is just for informational purposes only, and of course, consult with a professional in your state. But friendly disclaimer out of the way. What happens to your business if you die, or potentially if you leave some other way? Maybe you retire, maybe unfortunately you become permanently disabled and you can't work. So what happens? But let's start with probably one of the more common cases, which would be the case of death, where a co-owner passes away or a single owner passes away. What happens? So typically on death, your asset, a business is an asset. So you would have an asset that is being transferred on your death. That's going to be governed by your one of two things, either your estate planning documents or some other designation of succession, which you absolutely should have. You don't want the state making decisions for you in the second option, which if you don't have those documents, your assets are going to pass according to your state's laws of intestacy, which will be to the surviving spouse first in most cases, and then after that to any surviving children. But if you don't have any of that, then it starts to get crazy. It might go to your parents, it might go to siblings and things of that nature. But the state is making that decision versus the estate planning documents. But anyways, what happens if you become disabled? Well, that also potentially depends on other estate planning documents. If you're still competent, if you can still make decisions for yourself, then in most cases you're going to be holding the ownership interest, but you can't work. So now the business is struggling without you, and generally in smaller businesses and sole owner situations, the business depends on you. So, or even if you have co-owners, your partners depend on you. So that is a big problem. Now, even worse, if the person loses a capacity, if they can no longer make decisions for themselves and they haven't designated succession or executed something like a power of attorney or something to give somebody else control while they're incapacitated, those shares are stuck in their name. And the only way to get those is either a transfer on death through probate, which is terrible, and or a guardianship, which is even worse because now you're fighting over the person while they're still alive in court, but not in a estate planning video. Um, so that's kind of what would happen if you were disabled. Also, what if you're terminated? If you somehow get let go or you decide to retire? Again, depends on the formation documents and contracts that would be in place at the time. If they're not there, then depends on state law, but that gets very unclear and very messy, very fast. But let's go back to death. So what happens now if you have partners? And this is pretty tragic. Your partners are now stuck with your family. Like I mentioned, they usually will pass your family either through succession documents or intestacy. So now your family, who was probably not savvy in the business, or even worse, they don't want to be involved with the business at all, is stuck holding your equity and in this arrangement now with your partner. They also did not receive any cash for that equity. They didn't get anything other than an appreciated asset. And now they're stuck with something that is relatively hard to sell. It's pretty hard to sell a non-controlling interest or a 50-50 interest or even a controlling interest in a smaller business like that where there's other partners and somebody has to come in and now they're working with somebody that they don't know. I mean, it's possible, but it's very, very difficult to do. It's usually an unmarketable or very hard to market asset. And the other partners may not see it as practical to buy. There's no necessary reason to do it. They already have a controlling interest, and there's no real reason to come up with all this cash. That again leads to litigation and other disputes, which um, is messy, time consuming, and extremely expensive. So now you're in one of two situations. There's that dispute, like I just mentioned, or you have a partner who is negotiating with a grieving family, which is really, really sucks if the family knew the other partner and now uh they're they're in the midst of negotiating with somebody that their father or mother has known for years over an asset, and they're also grieving at the same time. So it's really just a terrible, terrible situation. But there is one solution that does work really well for this. It's called a buy-sell agreement. Very creatively named. Buy-sell agreement is basically one party buys shares, one party sells. Pretty freaking simple. Lawyers are not creative with their naming of certain tools. But basically, either the company or the other co-owners that are remaining, or both. Sometimes maybe there's an option to one of them or something like that. Those are going to buy, and the family is agreeing to sell under the agreement, or the remaining owner, or excuse me, the departing owner is agreeing to sell. That's the agreement. Now, how much? It's a good question. Probably a question for a valuation expert or appraiser. But generally speaking, the agreement is going to provide for some sort of formula or calculation that the value of the shares are calculated on. That formula is usually based around book values, old tax returns, whatever the valuation experts and appraisers come up with, some combination thereof. And usually it's pretty helpful because you can also in that formula differentiate which the you can also differentiate what the price would be depending on what the trigger event was, right? Remember I mentioned earlier in the video where you're leaving. It could be disability, it could be death, it could be maybe you're starting a competing business and you just want to sell your shares off. In some cases, this is helpful because where you would pay maybe less to somebody who is leaving to start a competing venture, you can come up with a formula that does that, but also pays more for somebody's debt or a certain amount on disability or some other way. So natural question now is how is it funded? Where are we getting the cash for this? And generally speaking, it's gonna come down to some form of insurance. If you're depending on what the trigger is, if it's for transfer on debt, then that would be life insurance. Either the company or the co-owners are going to maintain policies and then become the beneficiaries of those policies, take the proceeds when the trigger happens, and pay that to the now share owners. Typically, in a disability situation, if it's likely or people have the foresight to do it, they would have disability insurance in the same fashion, and the agreement would cover those terms. I don't want to get too much into the weeds. But what is the main benefit? Well, to who? Since there's three people here, the company, the departing owner, and the remaining owners, it's a win-win-win. Everybody wins in this situation. How does the company win? The company is getting continuity of management, where they already have a succession plan in place based on the agreement. So they know who is going to come in and manage the company if one person leaves for some reason. Or excuse me, and they're also avoiding unwanted third parties, like I mentioned, potentially a lazy son, or maybe just a son that's not interested in the business, or daughter or whoever coming in, and or maybe a controlling spouse or something you don't know. Um, the point is you're avoiding somebody that you don't know coming in and managing the business that may not have the experience or desire to do so. Lastly, there's also, like I mentioned earlier, there's usually a predictable source of funding. So whether that's going to be some form of insurance or there's some capital set aside, or however they decide to fund it, there's typically that is provided for. The business is ready to either take in those funds or usually expend them. But what are the remaining owners getting? similar benefits to the company, right? They're getting continuity of management. They're going to be able to stay on and keep control of the company and keep operations moving the way they need to keep the business going. They're also getting pretty clear terms. Like I mentioned with the business, they're getting clear terms to acquire and value the interest. And also, like I mentioned, that predictable type of payment that is not going to disrupt the operation of the business, having to come up with X amount and expend it at a certain time. They're also not going to be stuck and pulled into a dispute, like I mentioned, with a grieving family or potentially some other party that is mourning the loss of an owner that's usually put in decades of time and energy and effort into that business. So it gets pretty emotional. But lastly, the departing owner is also getting a very good deal. Why? They're getting, remember, I said that this interest in this business is most times in a smaller type business, not necessarily small in revenue, but maybe closely held or limited number of owners. It's intimate. The owners all work in the business. In that type of a smaller business, you now have a predictable cash sale of a otherwise hard to market asset. It's usually hard to sell that. So now they have a prediction of, okay, I am going to get my chips out of this pot at the end of the road. That's pretty clear. And more importantly, even in most cases, like I mentioned, where it's a smaller business like that, it's even harder to sell because a buyer of that interest is going to pay a premium for a cleaner book of records from both an accounting and a legal perspective, but not getting too much into the valuation of that in this video. But the point is, most of those smaller businesses don't do that. So it's really a hard to market asset. The second main benefit is that there's an estate tax planning vehicle here, and it's really probably understated the way I'm going to describe it right now, but it is unbelievable. It's really a estate planning video. But the point is, when you pass away, any assets that you pass on death are subject to an estate tax. There's a certain amount that they can be where there's no tax applied. If they exceed that, estate tax on that excessive amount. The buy sell is valuing the shares. So you have a predictable value in some way of what that asset's going to be at the time of death, and you're able to plan for that. It's going to impact other portions of your estate plan. Last main benefit is that the surviving heirs, whether it's family or spouse or children or whatever, now they're not grieving and negotiating at the same time. They already know what is going to happen, right? Income is going to be available for a surviving spouse or a disabled child or or a child or somebody that needs it. They're going to have it predictable and available, and there's no way that they're now being forced into a negotiation because the other partners want to continue the business and take care of their families while they're still grieving the loss of someone in theirs. So you're keeping the beneficiaries out of that negotiation. You're also keeping them from getting pulled into a business that they may not want to or be qualified to be a part of, or even worse, you're keeping them out of a dispute with either the business or really the co-owners in either case. I spoke a lot about co-owners there, but it's not just for co-owners. A single benefit, or excuse me, a single owner business can benefit as well if they were to enter into one potentially with, a colleague, a friend, some other, maybe a competitor, to take over the business on their death or something like that. Because now they're avoiding the same problems. They're not, even if you're a single owner, you still might not want children or other family getting pulled into that business or having to sell it, market it, and go through all that. And even worse, having to do that in probate, subject, subject to all those orders and things like that, where now, if you've already provided for that, even if you're a single owner, you're able to take care of that, and your family is going to have a predictable source to live off of in the event that the owner unfortunately passes away or there's some other trigger. So hopefully that gives you an overview of the benefits of that, gave you an idea of what happens when somebody dies and does not plan for it, but think it's pretty suffice to say you absolutely 100% need a succession plan. So if you need help with that or business related matters generally, like I said, please do reach out to me. My website is tarolaw.com. All that information is going to be included in the description below. And make sure you like the video, subscribe. Please leave me a comment and give me some feedback and let me know what you think. I'd be happy to keep making more of these. I just would love to see what topics you're interested in. So thanks for watching. I'll see you in the next one.